Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. I'm your host for today, Jeny Maier. Today's episode is What's Happening in MENA? Trends and Developments in Middle East and Egyptian Antitrust. We here at our Curious Amalgam are enthusiastic and always very curious to learn about competition and consumer protection law issues from around the world. And we've been thrilled to see our audience expand and grow from across the globe, from the US and Canada to the UK and Europe, across Asia, Latin America, Africa, and Australia, New Zealand. On this episode of our Curious Amalgam, we'll explore a new region, the Middle East. Today, we will learn which jurisdictions have active competition law and foreign direct investment regulatory regimes, what are some of the leading cases in these areas, and how lawyers can effectively counsel their clients on matters in these jurisdictions. With me today is my co-host, Matthew Hull. Hello, Matthew.
Hi, Jeny. It's good to be back.
Indeed, Matthew. Who's our guest today?
Well, our guest today, we're very pleased to welcome Nicolas Bremer. Nicolas is a partner and attorney with the regional law firm Bremer, where he heads the firm's antitrust and merger control and M&A teams. He specializes in advising clients from Europe and the MENA region on mergers and acquisitions and merger control in Saudi Arabia, the United Arab Emirates, and Germany in English, Arabic, and German. Hello, Nicolas, and welcome to the show.
Hi.
Thank you very much for joining us today. So we're going to be looking at Middle Eastern competition law. Our focus will be on, for these purposes, will be on Egypt, Saudi Arabia, and Kuwait. But we should also note, I think, right up front that the UAE is a hub for the Middle East, of course, for a lot of companies. But my understanding is it's at the moment largely inactive in both merger control and general competition law enforcement. But Nicolas, can you just take us through, firstly, at a high level, the Middle Eastern position in terms of merger control, general competition law, or even the subsidy rules that are in place, and then which are the most important and active regimes we should be considering?
Sure. Pleasure to be here. And as you said, the UAE is pretty much the most significant business hub for the region. However, in merger control and antitrust, they are sort of behind the most recent round of amendments or reforms in the region, which started late 2019 in Saudi Arabia, then went over to Kuwait, and Egypt is a little bit of a particular case, but I think we'll get into that a little bit later. And throughout the region, particular in Saudi Arabia and Kuwait, the authorities are still most active in the merger control field. There is a little bit of an increase in antitrust investigations, and Kuwait just had their first investigations completed where they issued fines. But still, the authorities' main activity is in the merger control area, and sort of the uptick in activity in Saudi Arabia and Kuwait came with them shifting from a market share threshold model to a turnover-based threshold model, and that just increased the scope of the regime catching, especially foreign-to-foreign transactions. In Egypt, we still have much more activity in cartels and behavioral cases, though that is likely going to change because at the end of last year, Egypt announced that they're moving from a post-closing notification regime in merger control to a pre-closing notification regime. It is not active right now. The most recent rumors are that it will start, or the authority will start enforcing it in mid-June, although there have been now some rumors saying that it might be delayed until early July. So that will drastically change what is going on in Egypt, I believe. But to date, Egypt is a more rather an antitrust jurisdiction than a merger control jurisdiction.
Okay, that's very interesting. Those dates will, of course, be during 2023. So
that's right.
Merger control right at the top, and then we have anti-competitive practices generally a bit lesser, although maybe more in Egypt. Of course, something we are worried about as antitrust lawyers related to the merger side is the proliferation of FDI, foreign indirect investment regimes around the world. Very briefly, is that something that is done in parallel in some of these countries, or are there standalone FDI regimes as well we should be worried about?
Not to the extent that we have that in for example, in Europe, where there's a lot of that activity right now. In the Middle East, they do have, and including all three jurisdictions we're talking about here, have FDI laws. However, the FDI regime is still rather traditional, like prohibiting foreign investors to be active in certain sectors or specific requirements that foreign investors have to fulfill. But there's no FDI review, so to say, for transactions. The only exceptions are in all three jurisdictions when you do directly acquire shares in local entities. But that review process is also very rudimentary compared to what we've seen in Europe. So it does not compare to any, or in detail or in extent to anything that we have in Europe.
Okay, so at least at the moment, it sounds like FDI is more of a tick box type of thing than the very wide-ranging cases or laws we're seeing in many other jurisdictions. Nicolas, let's just look at some high-profile cases that our audience might have heard about in some of these jurisdictions. Can you just identify anything that's really jumps to mind in terms of merger control or general competition law enforcement where, it's pretty high profile, and just to set the scene for a bit more here?
I think in Saudi Arabia, the two cases that did cause some waves were two transactions, two acquisitions that the authority blocked in 2022. One of which concerned, was rather local focused, but concerned distribution of natural gas to households, so ultimately consumers, which they opposed on pretty solid competition concern grounds. Effectively, the merger would have created, or the acquisition would have created a 70% market share, a concentration of 70% market share in one entity. The other one was much more debated, and that was the acquisition of a food delivery app, or proposed acquisition of a food delivery app called Le Chef, which is a Saudi delivery app that focuses on high-end foods. And the acquirer was Delivery Hero, a German-based food delivery app provider. The Saudi authority blocked this, and ultimately the reason they gave was that Delivery Hero was late in responding to an RFI from the authority. That was, so to speak, the straw that broke the camel's back. Sorry, but that was not the only reason that the transaction raised concerns in Saudi Arabia. And that maybe going to the FDI issue, it seems that in this transaction, some FDI concerns seeped into the merger control process. Like Le Chef was one of the few Saudi digital startups that was very successful and was seen sort of as a local champion. And there were in Saudi Arabia concerns, or there was there was in some parts of the administration the wish to keep this entity in Saudi hands and not have it acquired by a foreign entity. So the transaction concerned a lot of companies that are active in the region because of this very drastic or perceived very drastic response to missing the deadline on an RFI. If you go below the surface, it does raise concerns in another area that they would consider FDI issues in a merger control filing. However, this drastic response to an RFI has not repeated since.
Well, that's an interesting one. And Nicolas, I mean, it sounds like, as you say, FDI was seeping into it, although it doesn't sound like there's much of a kind of national security type concern about a food delivery app. But nevertheless, they were worried about local ownership.
Yes. I mean, we've seen these elements of national security come into play in an authority deciding whether to call in a transaction or not, but then not necessarily in the review process. And here, yes, it was part of a review process, but rather on a local ownership perspective.
Nicolas, so just follow up on something that you had mentioned a little while ago, that a number of these regimes have moved from market share-based thresholds to turnover-based thresholds, and they're now capturing potentially more global or foreign-to-foreign transactions. How are you seeing these authorities, if they are coordinating with other regimes around the world on deals that may be across jurisdictions or even across the globe?
Still rather limited. I mean, the Egyptians a little bit more so than the Kuwaiti or the Saudi authority do review decisions of the European Commission. In general, the whole region pretty much looks towards the European Commission rather than American authorities or other domestic authorities. However, inner region cooperation is still extremely limited. So there are some forums that are designed for authorities from the region to speak to each other. For example, there's an MOU between Kuwait and Saudi Arabia to cooperate on merger control and competition matters. However, there has not been that much traction on that. And then more recently, in 2022, there was a pan-regional forum created called the Arab Competition Network. They have had first meetings, but from what we understand, these meetings were largely on policy rather than specific transactions. And outside of the region, we have no evidence on them actively communicating with an authority such as the European Commission or US authorities or the CMA in the UK.
Okay, that's interesting. Nicolas, and sticking on merger control for a moment, of course, an issue is often discussed in Europe, the US, and Asia at the moment is mergers in the digital sector.
None of the regimes currently actively addresses this with any policy. So we don't have these same regulatory developments as we would have seen in Europe, for example.
What about private equity transactions? Have they developed transactions, Nicolas? Obviously, these are often worldwide transactions, and there are issues now, long established rules to look at turnover and control issues and the like in Europe and the US that many listeners will be familiar with. But what about these types of issues in these jurisdictions? Have they developed their practice in this area yet?
To a certain degree. In the beginning, when these regimes became active, we typically had issues with the legal teams when it came to PE transactions, largely because similar structures are not foreseen in local corporate law. So they're just not familiar with the structure, specifically the falling apart between management company and managed funds, that they have no corporate relationship to each other, or typically don't. That has held us up in a couple of transactions early on, especially in Saudi Arabia. That has gotten a lot better. However, there are still no firm guidelines on what they would look at. So specifically, are they taking an approach to limit their review to the acquiring fund, or would they look at all funds managed by the same fund management company? There is not really a lot of substance to this, partly due to lack of published decisions. And in our experience, there's case handlers take varying views on this, saying that in some transactions they will accept filings just based on acquiring fund, often not even asking for potential overlap to other funds managed by the same management companies. But there have been a couple of cases where case handlers were asking for information across all funds managed by the same company. So there is still a bit of ambiguity in this, or development in this.
Okay. Before we move off merger control, Nicolas, again, looking at these jurisdictions we're focusing on, how do you see it from what we'd expect in more established jurisdictions? Do you see that we can expect a traditional competition law assessment and appeal rights and a proper appeal process as we would expect? I mean, you mentioned, for example, this issue of the Saudi Arabian case where there was a combined 70% share and it ran into difficulties, which would presumably likely be the same in other more developed jurisdictions. But at the same time, you mentioned bleeding in of FDI issues into some of these cases. You mentioned that Saudi Arabia has a very wide effects revenue test or threshold. Is there a lot of uncertainty at the kind of case handler level and then an appeal level, or as I say, can we expect often what we would recognize as a process in the more developed jurisdictions?
We have seen considerable development, especially in Saudi, on sort of the case handler level. I mean, to bear in mind, while Saudi Arabia before September 2019 had a merger control regime, but at that point they were very inactive, and the authority was very small in terms of manpower and funding. That has changed dramatically. So essentially, we're talking about an enforcement practice history of about 3.5, 4 years here. So there are a lot of birthing pains still to overcome, but we have seen rising professionalism and predictability in the assessment, and especially in Saudi Arabia. Kuwait is still a little bit behind, but Kuwait also just started in summer 2021, so they lack a little bit more experience. And in Egypt, I wouldn't really draw conclusions from their application of the post-closing regime to the pre-closing regime that's pending right now, because we're talking about something completely different. But across all of these jurisdictions, when it comes to appeals, possibly challenging administrative decisions in courts, that is always a little bit more difficult. Their understanding of public to private relationship is just a little bit starker in hierarchy than we would expect that from Europe or the US or other Western models. So courts are generally somewhat reluctant to review administrative decisions or to overturn them. In trend, they lean stronger towards siding with these, and in some cases, courts have even found themselves to have no jurisdiction to review them. So appeals are difficult in this region.
I'm picking up on one of your earlier comments. As you say, of course, it's these regimes haven't been operating for very long. And I was also interested in your earlier comment that they don't seem to be cooperating or discussing cases with either amongst within the area or outside the area as well. They don't seem to be discussing cases with the Commission, the CMA, the US DOJ, FTC. So there wouldn't be a lot of, it sounds like there wouldn't be a lot of learning being transferred rapidly through those routes.
Yeah, that is one of the concerns, and so far, regrettably, we don't have that many positive examples of that. There were a couple of workshops or small-size conferences held within this Arab competition forum, but that is really at the beginning stage. I mean, this started in 2022, so we haven't seen that much development. There are from time to time advisors that are retained by these authorities from more established competition jurisdictions. However, that's always limited to a certain or to a specific term contract of these advisors, and there's not that much exchange. Another thing that does hinder sort of a building of institutional experience and predictability from the private sector side is the lack of published findings. So publications on cases and decisions in general is very limited in scope and often does not give or shed much light on the findings of the authority. So that makes it a little bit more difficult from the outside to predict their decisions, because we just often don't know what the root cause of their decision was or what the basis was. But it also, when talking to case handlers at the authorities, you quickly notice that there is no, or at least a lack of continuous record keeping on decisions and findings within the authority. So they often do not have previous decisions with extensive findings to base their decisions on, which then leads to more ambiguity and less of a institutional learning process. And that definitely is a concern. We're of course hoping that will change, and we've seen the Egyptians more than the others, but also the Saudis growingly now reach out to other authorities trying to place secondments, and that will hopefully bring some more development there.
Let's move on to general competition law. You said at the beginning, Nicolas, that merger control is and has been the focus, but also that there is some competition, general competition or antitrust law enforcement. I think you flagged up Egypt as probably the leading example of that amongst these three jurisdictions we're focusing on principally here. So what has been going on in Egypt in terms of general antitrust enforcement outside the merger control segment?
Yes, that's true. Egypt is the most active in this area, and most notably, they also develop theories and precedents on more indirect forms of anti-competitive behavior. So throughout the region, and for developing antitrust jurisdiction, I believe that's quite normal. But the first cases that we've seen were against a very direct anti-competitive behavior, such as price fixing or market division. Egypt has earlier this year concluded their first investigation into violations through information exchange, specifically hubs and spokes arrangements. So there are more, or they're increasingly also looking at these indirect effects or of behaviors. and in general show more sophistication in what is going on here. It's still a developing process, so we still don't have a very complex or very comprehensive understanding of how the Egyptian authority would address information exchange in models such as hubs and spokes arrangements. However, it does seem very heavily influenced by precedents of the European Commission. But similar developments we haven't seen in Saudi Arabia or Kuwait yet. There it has been much more focused on abuse of dominance cases, price fixing, and these type of behaviors. Notably in Kuwait, we have had the first two cases where penalties were issued. One was an abuse of dominance case concerning supermarkets and their contractual relationships with suppliers. Specifically supermarkets forcing suppliers to give discounts or sell at reduced prices to them, where the authority in Kuwait argued that they were using their dominant position in the Kuwaiti market to force these suppliers to provide these discounts. One other case that has concerned me a little bit in Kuwait was their investigation into reinforced steel manufacturing businesses. And there they ultimately did not find that the companies violated the competition law by through anti-competitive practices, but one of the companies involved in the investigation failed to provide them with information that they had requested as part of this investigation, and they fined them with a fine that was 750,000 Kuwaiti dinar, that is about 2.2 million US dollars. The level, but the gross amount might not be that worrying, but that constituted 1% of that company's annual.
Moving on to perhaps a more practical segment of the conversation, talking about how attorneys should be kind of keeping an eye on this area of the world and counseling their clients about compliance with the laws in the Middle East. What do you see companies, your clients, doing in terms of ensuring that they are in compliance with the laws in the areas that they're doing business, and what you're seeing in terms of trends for compliance on the merger control side?
So one measurement we've seen more and more pop up over the last couple of years is training of local staff. I mean, that is something, if you're active in that region, you should be mindful of, because the region does not have a long tradition of competition law, meaning local staff is not necessarily used to this. So what multinationals have been starting to do is either through their own teams or including experts from law firms or other service providers to conduct competition law and antitrust trainings for their staff. That is also a good idea in terms of preventing or addressing possible ramifications of issues arising, because the Saudi authority, for example, has recently issued guidelines on how to implement competition compliant behavior in businesses. Trainings are specifically listed there, and there is the hope that in case something should go wrong, if the company can show a track record of having taken reasonable and effective measures to address this, that could be positively considered in cases where incompliant behavior is found by individual staff, for example. That is sort of the more practical. It also pays off to look into your distributor networks. Distribution partners in the region will also be less acquainted to competition law issues. One aspect might be just to explain to them why certain processes are introduced to avoid complications in a business relationship. But the other issue also is of course that you would want to avoid anti-competitive behavior from your distributors or because that could negatively reflect on your business. Outside of that, in terms of merger control, I do appreciate that these jurisdictions pop up quite a lot in sort of multi-jurisdictional reviews. It does not always mean that a filing is necessary. There seems still in a couple of also globally operating firms this idea that, for example, in Saudi Arabia, as soon as the threshold is met, you have to file. There is a local nexus test, so analyzing that and looking a bit at the transaction and its effects or the parties' engagements in the regions does pay off, and some filings or some situations where initially it might look like a filing is required will then ultimately turn out as no filing being required. But observing the region and also observing the changes that are implemented is I think, for law firms essential to advise their clients on whether activities in the region are required.
Great. Well, perhaps maybe just to wrap us up, are there any other sort of practical tips that lawyers or companies that have businesses in the region should be keeping in mind from the competition law point of view?
Maybe not so much necessarily a competition law point of view, but something that the region just responds to quite well is personal contacts. I do appreciate that after COVID and the introduction of Teams, Zoom, and other conferencing systems, everybody's kind of used to doing these meetings remotely. However, the Middle East still has a very much face-to-face culture, and they preserved that through the pandemic. So if you can take a meeting face-to-face to discuss an issue, that is much better than doing it over Teams or Zooms, although the authorities are growingly adaptive here, and they're accepting that. And better than sending over an email often is just giving the case handler a quick call and discuss. One, because they just respond to it better. It's a cultural issue. And two, also because they might be more willing to give you an estimate if they don't have to put it in writing. Like, look, if we're looking for timeline, when can we expect clearance or a decision on a certain matter, we've just noticed that they're more willing to give us this estimate if they don't have to put it in writing and feel like they're going to be held by this.
Those are great insights, Nicolas. Thank you so much for your insights on the practice and on the substance. We've really learned a lot here today. And now it's time for the portion of our program where we get to be a little curious about you personally and learn a little bit more about you and your history here. So can you tell us something that's interesting or unusual about yourself that we wouldn't know if we only knew you professionally?
Yeah, I knew that this question was coming, as I'm a frequent listener of the podcast. I think that there are two issues. One, the one question that I often get in first meetings is how did a German lawyer end up in the Middle East? And that is related to, I wrote my PhD on a Middle Eastern topic, went to the region for what was supposed to be a very short research trip, and then ended up staying the first time for about 2.5 years, in part because my then girlfriend, now wife, found a job in the region, and that kind of grounded us there. I learned the language, and so then, and this might sound negative, but I don't mean it like that, I was kind of typecast as the Middle Eastern guy. I do enjoy my time there a lot, so it's not sort of a regret of mine. But something that people who deal with me professionally might know but don't know that much outside of my entire professional life is I'm a very passionate skier, and mostly outside of the groomed resort slopes. I live in a very bad region to do that, so I have to fly quite a distance. There is some skiing in the region, but it's very limited, and season is very short. So I in the winter I try to get over to Europe and to the US a lot to fancy that hobby of mine. But the ski dome in Dubai is not really a supplement for the Rockies or the Alps.
I can imagine. So now is the final segment of our program, which you may know as a frequent listener of the podcast. It is called The Curious Hat.
And now it's time for The Curious Hat!
All right, Nicholas. So as you know, we have an imaginary hat here that I am holding. And I would ask you to pick a number between 1 and 12, and I will choose the question for you.
Let's go for 8.
No. When you were a young child, what did you want to be when you grew up?
Oh, that changed a bit. In the beginning, I wanted to be a construction worker. My father is a civil engineer, so he took me out to construction sites. And one of my proudest moments as a little 4-year-old was sitting on a excavator driver's lap and pretending to man around the shovel. And then when I got a bit older, I wanted to become a pharmacist. My mother is a pharmacist, but when my chemistry grades came back, that was not so much of a realistic option.
Well, I don't know any 4-year-old boy that doesn't like diggers and dump trucks.
That's true.
Well, Nicholas, we thank you so much today for joining us on our Curious Amalgam. Thank you all for listening to this episode, and we look forward to seeing you again next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.